Ms. Silver and Mr. Lana, you both have the right to argue. Are you going to split your time? Are you going to put them together? How do you want to do that? Yeah, I think you are, Ms. Silver.
I think what we're thinking is reserve 5 minutes for rebuttal, and also have Max come in at the last 5 minutes of argument. So 10, 5, and then 5.
Okay.
Is that right? 10, yeah.
Okay, you first and then him and then 5 for rebuttal.
Okay, sounds good. Thank you. Well, this case, as you know, is about a review of a non-final order denying a disqualification of one co-defendant, George Filos, acting as counsel for the remaining co-defendants on the case. At the time that this case was filed, and the briefs were actually also filed, there wasn't really, neither side had an actual case where a co-defendant had actually tried, even attempted. I couldn't find any cases. Our opponents didn't cite any cases where a co-defendant actually came in and acted as counsel to the remaining co-defendants. Clearly, that's a blatant violation of due process in that it hampers discovery and creates all kinds of problems that were discussed in the initial brief in the first part of the argument. It's also a violation of the Florida code, the bar code. And recently, Law 360 carried 2 cases, and this was in the sphere of cannabis law, where cannabis attorneys tried to act as co-defendants, as counsel to their co-defendants in various suits. This notice of supplemental authority was filed and docketed yesterday, so I'm not sure everybody has had a chance to go through that. But basically, even though this has been allowed to go on, it doesn't mean we haven't objected. Max couldn't object for a number of years because he was under the jurisdiction of the court without any sort of representation other than myself, who became a law student in January 2015 and got my degree in January 2017 in a 2-year program. So during the pendency of this case, this civil case that we're talking about, which was dismissed via summary judgment in 165069, upheld there by PCA, and also then led to a slew of attorney's fees, appellate fees, just unbelievable fees for Mr. Filos, an absolute defendant in the case. And I just want to tell you, because there's 2 volumes in the appendix, over 5,000 pages. Hello?
How is he a defendant?
How is he defendant? Well, the way a person generally becomes defendant is the plaintiff names them in a complaint. So I just want to, I'm sorry, Your Honor. I can't hear you, sorry.
To do more than just put them in the complaint?
Well, let me go through this. There is a timeline in the Master Index Appendix 3, and on page 31, Volume 3, there are 3 volumes to the appendices. 2 are substantive and have several thousand pages supporting. Now I'm going to give you the record evidence as to how he became a defendant. But I'm reading off a timeline that you can see as a snapshot. There's a transcript.
Counsel, this case, among other things, Mr. Filos says he was never served with process. Is that accurate?
He received e-service of the initial complaint. He then came to a hearing acting on his own behalf, as the transcript says, and you can refer to the transcript. He actually attached it in his own appendix, but it is in the appendix. There was a hearing in open court where Mr. Filos admitted that he was a defendant when asked by the judge. And basically then the caption was changed. So let me just read you this from the initial brief, because I'd like you to give me an opportunity to get to the facts, if you may. So if you look here, the initial brief does a painstaking job of breaking down moment by moment how this came to be. In this section,
let me ask you a question.
He was, can I answer that first question? Because I think it's very, it has to be answered as unpleasant as it may, as its consequences may be, or as much water as has gone over the dam. I think we can't still keep glossing over it. So I'm being asked a question. I have to be given an opportunity to prevent a record citation. So let me just give you that record citation kindly, in all due respect, because that fact has to be heard, I believe. On January 23rd, Section D, Statement of Case and Facts, page 19 of the initial brief. And that, by the way, is reference to, if you can see, Appendix 2, page 950 to 978, with an excerpt at 940 to 949 of the transcript of the January 23rd, 2015 hearing. And this is what was said at that hearing. And that has been actually, the hearing transcript is also in the appellee's very pithy appendix. Here's what we see in Section D. During the hearing, the court said, the order amending the caption, because remember, the caption initially was Alexander's versus the trust. It was improper for me as trustee, and nor was my issue with the trust. My issue with tortious interference and the essential appropriation of every inter vivo transfer that had been transferred, it had been in trust for my son, most of them, until my father died, at which point they were promptly changed to Alexander, the deceased appellee. So here's what happened at the hearing, reading there. The defendant shall be those three named in the amended complaint, said the judge, the trial judge. Alexander, Plato, and yourself. He is addressing Mr. Philos. Mr. Philos says, and myself, yes, Your Honor. If Mr. Philos had a problem with service of a complaint in August 2014, then by January 2015, he should have raised it, or the court should have raised it, because we don't throw out whole complaints because a pro se party serves an attorney who's been on the case for 5 years. Understand it was an amendment to an existing complaint. So the other parties, the Alexanders, who have a conflict, they've been wronged by this also, because you can't have two co-defendants, as the case I've submitted to you yesterday shows. The main problem actually is not just prejudice to us, to their opponents, but when a co-defendant acts as counsel for the other co-defendants in a complaint that have different theories of liability for each defendant, he perforce cannot, even in theory, represent them fairly. And he did not, as the record continues to show, that he actually impeded settlement until my uncle died, and we will never settle. So that is a very sad and tragic situation. And it would not have happened, as the record shows, if we were not constantly put in fear by counsel that was actually trying to dismiss the case without a jury trial, to not be a defendant, talk about material benefit. After he admits, and yes, Your Honor, I am a defendant, to the trial judge, because he could have said, no, service of process, at which point we would have quickly cured the small defect because it wasn't a notice issue. And notice is the purpose of the rule of process. So that formality, you can subject yourself to the jurisdiction of the court, and no one knows that better than Mr. Philos in Bush v. Shivo, also quoted, where the governor was forced, because he participated slightly, to submit to the jurisdiction of the court. So certainly what's good for the goose is good for the gander, but let's continue. The court went on January 23rd, 2015. This is the first amended complaint, which gave rise to a February 2015 order in the record that changes the caption to reflect the three names that you have seen for years in the filings in this case. So at the appellate level, he says, yeah, this one doesn't show Mr. Philos as a party, says the judge on January at this caption hearing. Okay, Evelana individually, says the judge, and as guardian of Max, etc., versus Alexander, Plato, and Mr. Philos. What's your first name? The trial judge asks Mr. Philos. He responds, George. Mr. Baskin says, the estate attorney, one of the better Georges. Court, and no middle initial used? Mr. Philos, no. Court, and George Philos. George J. Philos, Your Honor. Then the court turned to our then counsel, who was threatened by numerous sanctions, which are also in the record, and says to him, Mr. Ramos, our counsel at the time, the bottom line is, who are you suing? Alexander, Plato, and George, and not Nicole, because we dropped the estate's counsel because they were supposed to bring the suit. Indeed, a curator had been appointed to bring the suit. Interestingly enough, the orders that designate a curator to pursue the Alexanders and the accounting were somehow removed from the record for years by the clerk, not accidentally, because accidents don't happen like that. So then he says, yes, Your Honor. My attorney at that time, who was representing myself and had not yet filed a notice to appear on Max's behalf, but would shortly after, 2 weeks later, he then said, yes, Your Honor. So we have Mr. Philos spelling his name as a defendant, accepting in open court on a transcript that he's a defendant. But the plot thickens. It doesn't. So I proceed in my first year ignorance to try to do depositions because suddenly the case is rocket docketed to summary judgment. Mr. Filos refuses to identify himself as a party and asks me to subpoena him for depositions, which, since I was taking civil procedure at the time, I thought was rather odd, as did my professors, and they thought something was wrong with me. So you can see that there's an email I sent him. This all blew up during discovery because, as you know, the main problems, and that's what the case of Worley, the Supreme Court said, first and obviously, the law firm is not a client for a reason, because that leads to confusion on many levels. I've submitted copious authority on this, but I don't think any judge who's of your stature is unfamiliar with why attorneys are not also witnesses, let alone attorneys for co-defendants. So he knew he was going to be a witness because Mr. Filos also represented my deceased mother in a deathbed affidavit that was used to convince the courts of New York that she was well when she was dying. So that being another story, perhaps for another day, Mr. Filos was going to be called in as a witness, shouldn't have taken the case even before he was a defendant, in my view, because that was foreseeable. He was defending the deceased whose estate had been pillaged by the Alexanders. Every inter vivo, every account, including my father's pension, had been transferred upon my father's death
And
to
Miss,
my mother's older brother. So how is this not a conflict?
Silver,
Yes,
you're 10 minutes in. And so if you want to save the 5 for Mr. Lana and 5 for rebuttal, you need to stop at this point.
Am I at 10? Forgive me. Am I at 10?
But you're at 10, yes.
Oh, okay. I just want to say the last thing. The courts, and you know this from Larson's and all the authority cited, this court and other courts had a duty. There were court officers standing there who had a duty, not just to me, but above all to an infant, my son, who was not only represented by me, a law student in 2015 and not before, but also had this incredible super arrangement where a co-defendant, a famous local attorney, was representing the other co-defendants, and now comes back to haunt Max in his adulthood for fees that were paid in large part by Max's own distributorship. So Max, I know you have something prepared.
Okay, how about it, Mr. Lana? To reserve time for rebuttal, you have 4 now.
I have 4 minutes? Okay, thank you. So I was unrepresented. I'm just going to get straight into it. I was unrepresented as a minor until February 7th, 2017, when I was first substituted as a party in case 2D16-5069. Thus, I was unable to represent myself at every critical moment in this case, and no court officer did anything about that. Indeed, in Appendix 2, Volume 2, page 358, the estate attorneys wrote the following in his own motion to strike. On line number 2, there is no provision in the law for an individual to practice law in civil court pro se, purporting to represent the interests of others. The second issue that even were, I apologize. The second issue is that even were a New York lawyer to file such a pleading, the requirements would still require the court to approve petition to appear pro hac vici, pursuant to the Code of Conduct and the Code of Judicial Administration. The appellate record reflects this, especially at Appendix Volume 1, page 1127 through 1132, and Appendix Volume 2, page 147 through 185, that I was a minor in 2013 when the underlying civil case was brought by counsel, and also in December 23rd in 2015 when the offer of judgment was made, and also on October 21st, 2016, when the case was dismissed via summary judgment by a trial judge who was disqualified for prejudice 2 years later, and also on January 23rd, 2017, when entitlement to fees was determined. I was represented for the first time only for 5 days before the motion to determine fee amounts was adjudicated, and I was not even served the September 25th, 2017 motion to relitigate entitlement fees based on 57.105, and yet I suffered a severe sanction. So who was representing my interests during this relevant time? And how could I have objected to a defendant acting as counsel to his co-defendants? I'm assuming that the idea that I was represented by my mother and co-appellant, but how could any court allow that while she was being sanctioned for her filings? It's unclear why the officers of any court in this state would permit non-attorney who is routinely sanctioned the represents the interests of a minor unless the goal was for me to lose my claims. Thus, the record clearly shows that I was never adequately represented and no independent counsel has ever been appointed to represent my interests. This situation violates my constitutional rights and the laws of this state. In O'Brien versus Florida Birth-Related Neurologic, 710 South 2D51, it was found that the failure to appoint independent counsel in guardianship proceeding violated incompetent's right to due process. This court held the right of a party to be present at a trial is sacrosanct, and that adjudicating the right for an unrepresented infant departs from the essential requirements of law. Farango v. Yoder, 495 South 2D886. In Polycott, furthermore, in Polycott, Corp versus Hersich, 442 South 2D958. The Fourth District held that even leaving a corporation unrepresented by a person is fundamental error. Notably, the federal courts of the state echo the same sentiment regarding a non-attorney representing the interests of a minor or disabled ward.
Okay,
See,
Mr. Lana, I have to tell you, you're moving into the rebuttal time at this point. So,
oh, okay. How am I? Oh, I'm out of time already.
well, there's, your side is entitled to use all 20 minutes
Okay.
for the first argument if you wish, but you're using the rebuttal time at this point.
It's already 4 minutes. Oh my.
Yeah, it goes by quickly sometimes.
I apologize. I just to conclude really quickly, as a result of the history, I've been substantially harmed and held jointly liable for enormous judgments to financial payments made to defendant Philos, which have claims to receive from his co-defendant, Plato Alexander Jr., and his father, Alexander P. Alexander. My understanding is that the appellate will continue to seek additional fees as long as we continue to object to his unconstitutional and unjustified situation, which also violates the Florida Bar Rules of Professional Conduct. I appeal to the honorable court and pray that you will review the record and rule according to the facts of law so the fundamental errors in this case may be corrected and abated.
Okay.
Thank you.
Thanks.
Thank you. Sorry.
You're good. Mr. Philos, you're up.
Thank you, Your Honor. If it please the court, I'm George Philos of Philos and Philos, PA, and I represent Dr. Plato Alexander, the appellee in this case. Especially after listening to the two earlier oral arguments on the calendar this morning, it's evident this is quite a unique appeal in that it is so completely devoid of merit. It is so completely lacking in any factual or legal issue for review. One wonders, it begs the question, what is there to argue on oral argument? The facts, the undisputed facts in this appeal, not the prior decisions, not the prior appeals, not the prior opinions, but in this matter, there are simple, undisputed facts. The lower court in 2016 entered a final summary judgment in favor of Dr. Alexander and his now deceased father, Alex Alexander. The appellants appealed that final summary judgment to this court. That case was 2D16-5069. During the pendency of that appeal, Dr. Alexander and his father, Alex, requested appellate attorney's fees from this court. In December of 2019, when this court issued an opinion affirming the final summary judgment entered in favor of the Alexanders, granted the Alexanders' motion for appellate attorney's fees, and remanded to the trial court the determination of a reasonable amount of fees. Upon issuance of the mandate, Dr. Alexander filed a motion in the trial court saying, determine what our fees are that the appellate court granted us pursuant to the mandate. At that time, the appellant sought to disqualify Dr. Alexander's counsel because he has a conflict and is a co-defendant. The lower court correctly denied that motion because it is undisputed that the request for appellate attorney's fees was made by the Alexanders, not counsel individually. The order of this court in the summary judgment appeal awarding of fees granted the motion of the Alexanders, and Plato Alexander filed a motion in the lower court pursuant to the mandate to determine the amount of fees to which he was awarded. So the trial judge was eminently correct in saying there is no conflict because counsel is not a party to these proceedings. What this appeal really is, and what this oral argument on the part of the appellants is, an attempt to re-argue a final summary judgment entered by the trial court, what now, 6 years ago, and affirmance of this court entered 3 years ago. And in fact, in their brief, the appellants request this court to reverse those prior final judgments and this court's prior opinions. And simply, this court, as it well knows, has no jurisdiction to utilize this appeal as a vehicle for entering prior final orders of a court or prior opinions of this court. There are 2 cases cited in the brief. I'll just cite one of them in particular. The appellate court is without jurisdiction to consider the propriety of that earlier final order in an appeal from a subsequent order, even in the same case. Now, we took pains in our answer brief just to say that even if this court undertook the completely irrelevant examination of what occurred in the summary judgment proceedings 7 years ago, that it's obvious that counsel was not a party to that case. But the entire discussion is irrelevant to this appeal. So what this appeal really is a vehicle to delay the entry of a fee order that the lower court has been sitting on since last January, which it cannot enter pending the determination of this non-final appeal. What this appeal is really about is another frivolous effort on the part of the appellants to have the appellee incur more attorney's fees. What this appeal really is about is it gives the appellants an opportunity to vent their displeasure and distemper, not only against the opposing parties, but the clerks, the lower court judges, and even the Second District Court of Appeal. And it bears stating what is actually said, what has actually been alleged, written in the filings of this appeal. Regarding the lower court who entered the order being appealed, the appellants state that judge, open quotation, has a very anomalous history in the case, close quotation, open quotation. The judge could have written a completely true order, but instead chose a pre-printed form that was misleading, possibly to permit some deniability downstream, end quote.
Mr. Filos, can I ask you a question? Just summarize what you're saying.
Yes.
What you're saying is they moved to disqualify you because you were a party to the lawsuit. You're saying you never got served, you're not a party, so the denial of the motion to disqualify you was probably denied. Is that basically it?
Well, I'm saying, Your Honor, that the question of whether I was served with process, which I wasn't in the initial lawsuit 7 years ago that resulted in judgment, is irrelevant to this proceeding, because it's undisputed that in this proceeding is simply a lower court determination of reasonable attorney's fees requested by Plato Alexander based upon a judgment entered in an order entered in favor of Plato Alexander that has nothing to do with me. Now,
Here's what I'm saying. You were a party back then, you're not a party now, so the motion to disqualify you was properly dismissed or denied, correct?
it was properly denied. Of course, factually, I was never a party in the summary judgment proceedings 7 years ago, nor am I a party or have any interest in the current proceedings to determine a reasonable fee granted to my client. Now if the court likes, we can enter into an argument about what happened in a case 7 years ago that this court has no jurisdiction to consider now, but it's irrelevant. It's irrelevant to this proceeding. But no, I was never served with process. I was never served with process in the case. The hearing to which was mentioned in the first part of this, in the appellant's argument, was a hearing on many matters, and one was adjusting the caption of a case, adjusting the style of the case. The appellants filed an amended complaint listing me in the caption as a defendant. So the judge is saying, we need a new style of the case. What's your name? Do you have a middle initial? Yes, my name is George. I have a middle initial. And the trial judge also said, the caption of a case, in his words, means diddly. It means nothing. And if we're going through the intellectual exercise of what happened in a case this court has no jurisdiction to review now, we'll say the appellants never filed a motion in that proceeding to disqualify me as counsel. They never served me with process. Even after they admit they knew that I didn't consider myself a party, they never even served me with process then.
I think I understand it. I was just kind of trying to get to the bottom line, which I think I understand.
Okay. So if I may ask, Your Honor, how much time I have left? I think you're muted.
You have 9 minutes left, Mr. Felix.
9 minutes left.
You don't need to use all your time.
You never get points off for failing to use all your time. That's
Okay.
but feel free to if you wish.
Yes. What I wanted to mention as well, and why I was listing or mentioning some of the things that appellants have said and submitted to this court, because it's an affront. It's an affront to the dignity of this court. They've called the predecessor trial, they've accused the predecessor trial judge of clearly conspiring with opposing counsel. They've accused the predecessor trial judge of quoting, this conflict is the product of a corrupt conspiracy involving a state judge. They've accused the clerks of deliberately corrupting the record on appeal. And they've accused this court of pre-deciding this case before it ever received it, because they've somehow altered or manipulated the captions of prior appeals. Now, granted, there are pro se parties. There are pro se parties on the other side. And we might excuse some of that conduct from pro se parties, but one of those parties has a designation of Juris Doctor after their name. You would think that a Juris Doctor would know better than using the court for what I've called in the brief a vehicle for immunized slander. Not against myself per se, the parties, the clerks, the lower court judges, and this court. To conclude, we ask this court to promptly affirm the judgment of the lower court so the lower court can go on with its business and enter the fee order, the fee order and amount, which was mandated by this court in, the summary judgment appeal.
Can I clarify, Mr. Peebles, just to confirm my understanding, is that the only matter that is pending in the proceeding below, is that appellate fee issue?
That's it. That is the lower court proceeding determining what a reasonable appellate fee is.
Has a hearing been held on that?
A hearing has been held. The trial judge has not entered, but has prepared a final order.
It just hasn't been rendered.
It just awaits its filing with the clerk, which that last step can't be done pending this non-final.
And that was a offer of judgment statute to award, or offer of settlement statute award, and it was a straight award. It wasn't remanded for the lower court to determine whether it was a good offer. It was just.
That's correct, Your Honor. There was no issue of the entitlement. It was
just an amount.
Strictly an amount. And I might mention that the lower court in the summary judgment proceedings entered attorney's fees based on the trial fees, based on the offer of judgment statute, and also 57-105 entered it on both bases. And that fee judgment was appealed and affirmed by this court in another appeal. So we ask that the lower court be promptly affirmed. We ask that the court award 57-105 fees in this case. And just a note about that. One of the reasons for that statute is to try to make whole the defendant or appellee who is subject to a 57-105 suit, but it's also for the benefit of the court and its other litigants. You have, listening to especially the first oral argument today on that stop, you're arguing fine points of law. You have hundreds, if not thousands, of cases of fine points of law, that issues that need to be decided. You have the lives of families, businesses, individuals on hold while the Court of Appeal renders decisions in those cases. And a case such as this damages those litigants, damages the courts by taking your time and resource away of the important work that you need to do and are charged to do in a case like this, which absolutely has no merit. So we ask for a award of fees in this appeal, and we also ask this court to promptly issue its mandate. And so I conclude on that way, and thank you for your attention.
Thank you, Mr. Peebles. Okay, the appellant side has 4 minutes. So one or both of you can argue up to 4 minutes.
Hello. Can we get a pause for 1 second? Eva's having
Hi.
connection issues. Oh, never mind.
Hi,
Never mind.
hello? Okay.
Yeah. Go
Can
ahead.
I be heard? I'd like to say some things. First of all, fundamental error can be corrected anytime. When you don't have a case, what you want to say is nothing to see here. So Mr. Vilos cannot justify the fact that he admitted to the jurisdiction in open court, said he was a defendant, was told he was being sued, and he wasn't just in the caption. That's dishonest representation of the second amended complaint. He was in the claims. There were particular claims against him. So let's not pretend. Also, I would refer you to the Supreme Court in State v. Poole, which you know is a sea change. Stare decisis has been eviscerated if it's unconstitutional, and nothing can be more unconstitutional than what's happened here. So it's State v. Poole, 297, Southern 3rd, 487, a recent decision. Boyschiller Flexner wrote about the sea change and what this means for stare decisis. You, as the appellate court, have the authority to change something that is fundamentally flawed. And indeed, a very lengthy opinion was written by this court in Larson's Auto in 2021, going through fundamental error. And this is fundamental error. There is no reason a co-defendant should be paying one defendant should be paying another for fees and billing them. Mr. Filos could have defended himself, the other sign it, and appeared pro se. I also want to discuss other things. When you don't have a case, you sort of get the camaraderie of the court going, as Mr. Filos is famous in these parts, and basically say, oh, whoa, she's disparaging everyone. I want to draw your attention to a very serious matter. In Appendix 1, there is a table on page 274, and from page 258 to 796 are my constant, relentless objections and requests in May 2016 before discovery closed, all of them removed inexplicably by the court clerks, who on recordings have had a very difficult time explaining this to me. And I will tell you, look at Appendix 1, how a judge, a trial judge, who's a successor judge, and might we talk about the history of the successor judge? She was appointed randomly, and that's also in Appendix 1, the history of the successor judge. And you can look at case 2D19-6112, which was dismissed at the height of COVID, and we live in Manhattan, so we were truly suffering then. And it delineates how the successor judge, after the trial judge, who's biased and was removed for prejudice, was substituted. She just backed out of the case and would not even give us a hearing on a 2.330, which we're entitled to when somebody gets removed. Instead, Mr. Filos handpicked and played musical chairs with the judges. And this is all in the record. So I will basically implore you to look at Appendix 1 in the section on the judicial history. We are not wrong for saying what's there. There are over 400 pages missing in May 2016, where I objected in my law school net saying, look, you got to bifurcate the cases. You can't have the attorney be an attorney for the other defendants. All of these inexplicably missing, purged from the record. Every deposition that Mr. Filos took 3 days, purged from the record. Not even when I entered it as summary judgment evidence. There are so many manipulations of the record. And might I point out that this manipulation began so early in case 135538 that there actually is a probate court. If you see in Appendix 1, page 1121 to 1132, where the court, the lower court clerk, thin sliced the orders that show, one, that the Alexanders had promised to return the money, or had their attorney had. He now denies it and paid himself from it. And that a curator had been appointed to go after the res that is at issue here. And we waited with counsel for that curator to go after these accounts, which they needed for infants that are unrepresented to this day in this case. There is nothing that prevents this court or would allow it to turn a blind eye. You have a duty to correct fundamental error, especially in this case, might I add, as far as my credentials. I don't have as many years of practice in this court as Mr. Filos, but if you look at the matter of Simakopoulos, my first appeal on jurisdiction essentially revoked the fraudulent ancillary probate that was started by my sister in Florida with the assistance of the Alexanders, because they're the ones who filed the will here.
Your
So
time is up.
fundamentally, yes.
So you need to stop.
Please look at the record, because summing it up as he didn't get e-service doesn't really cut it.
Okay. Thank you
So
all.
I know that might provide comfort, because I've been objecting for years.
All right.
We had to remove the judge, and the successor judge wouldn't look at it.
Ms. Silver,
What do you do?
your time is up. In order to leave our virtual courtroom, on your Zoom screen is a leave button. It should be in red. You click that and you